Welcome to Employment Law This Week. I'm George Whipple. Our top story this week, OSHA fines are set to increase for the first time in a quarter of a century. Under the new bipartisan budget bill, OSHA civil penalties will rise next year to reflect the difference between the Consumer Price Index in 1990 and in 2015, an increase of as much as 82%. After this catch-up adjustment, the fines will keep pace with inflation. We asked Valerie Butera how employers can boost their safety programs to avoid OSHA citations.
I think that every employer should be concerned that OSHA might show up at their door at this point. As far as preparing, I think every employer needs to ensure that their safety policies are comprehensive and up to date. They should absolutely train all of their employees on every relevant safety policy, test them to ensure that their employees comprehend that training, and then keep documentation of the training on file. OSHA issues a lot of training citations, and having that kind of documentation is extremely effective in defending those citations.
The Affordable Care Act's birth control provisions are headed back to the Supreme Court. At issue is whether the ACA's opt-out process violates the Religious Freedom Restoration Act. Under the opt-out, religious organizations do not have to pay for contraception, but accommodations are made so that employees still receive coverage. The High Court will review a consolidation of 7 cases to decide whether the opt-out substantially burdens religious freedom. Like last year's landmark Hobby Lobby decision, this case addresses the extent to which corporations have the same rights as natural persons, and how those rights affect the company's legal obligations towards its employees. This is the latest case, but undoubtedly not the last one. The NLRB rules that Chipotle illegally fired an employee for participating in minimum wage protests. The board ruled that the firing by the chain was a violation of the National Labor Relations Act. Though the employee's supervisor claimed that he was fired for poor performance, the NLRB found the firing was motivated by his participation in the protests and his discussion of pay with other employees. Other restaurants are facing similar charges from the NLRB arising from the Show Me 15 protests. 2 federal class actions challenging off-the-clock security screenings reached different outcomes. Bath & Body Works recently agreed to settle a suit in California over unpaid overtime and off-the-clock security inspections. But a federal judge in the same state dismissed a similar class action against Apple, in which retail workers claim they should be compensated for time spent having their bags checked. The judge concluded that the employees were not performing job duties and could avoid the screenings by not bringing a bag or cell phone to work. And that brings us to our tip of the week. Here's Eugene Schlanger on how to prepare for employment issues before they arise.
Individuals are subject to increased scrutiny. The question is, how should a corporation respond? Most regulated entities, such as banks, have in place extensive written policies and procedures to operationalize their activities. I am suggesting that a third P, practice, be added, a team consisting of 1 representative from legal, 1 representative from human resources, who are ready and able to respond in real time to an employment situation. This may also potentially diffuse the situation because the affected employee, as well as the other employees, will know that there is a practice in place to address the event.
Thanks, Eugene. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.